Conversations with Nicole. Let's talk about it. Tell me all about it. I'm here. I wanna know what's on your mind. Ooh, the world needs to hear from you, and I'm so glad to have a conversation to reach the nation. And it's all about you. We'll help each other to discover innovative ways to positively change the world. Let's talk about. Let's talk about. Yeah. Let's talk about conversations with Nicole.
Greetings. Welcome to Conversations with Nicole. I am Nicole Everett, your host. And Conversations with Nicole is a talk show based in Tallahassee, Florida, focused on connecting the community through conversations. And today is what I call Wellness Wednesday, which is an opportunity for you, me, and my guests to chat about an interesting topic. And today we are talking wills and estate planning. Wills and estate planning, which to me is all about financial wellness, but also mental wellness. And my very special guest is attorney Felicia S.W. Thomas. She is no stranger to Conversations with Nicole, having been on before talking about guardianship and heirs property. But again, tonight we are diving into wills and estate planning. So that means probate, that means common mistakes, that means improper planning. What are some of the consequences if you don't plan? So this is going to be a good one. So you need to tag a friend and let them know they need to be on here. We are live on Facebook, on YouTube, and on uh, LinkedIn. And this is an interactive live. So your comments and questions are very much so welcome. If you would, put your city and state in the comments so we can give you a shout out. This is a safe space for us to engage with one another. So we fully expect to hear from y'all this evening. We do. I know that there is a Zoom going on with regards to Rattler Nation. So, I look forward to hearing what the results are from that meeting. But we're gonna have an important meeting right here tonight. So again, we want to hear from you. So definitely tag a friend and let them know they need to be on here. Your sisters, your brothers, your cousins, your kinfolk, because I know y'all ain't taking care of these things, or you have some questions about these things that we're going to discuss. But while you are coming on, I see a few of you, no comments yet, but I see a few of you out there. I'm going to go ahead and share attorney Felicia Thomas's bio. She is a practicing attorney with 26 years of experience, a published author and editor. She received her BS degree in journalism from the Florida A&M University, go Rattlers, and her Juris Doctorate degree from Florida State University College of Law, go Noles. She has obtained legal experience in a variety of areas, including the Second Judicial Circuit's Public Defender's Office, the Florida Parole Commission, the Reemployment Appeals Commission, and the Florida Department of Revenue. Currently, Attorney Thomas's practice includes guardianship law, wills and probate, and VA disability law. She is also a professional guardian. Attorney Thomas serves on the board of several nonprofits and is a member of the Florida State Guardianship Association and the Florida Healthcare Association. She has published a young adult novel, short stories, and served as a ghostwriter on other works. She's a native of Quincy, Florida, and the mother of 3 children. Y'all help me welcome attorney Felicia Thomas.
Good evening, everyone. Thanks for having me again.
My pleasure. I was thinking about
Yes.
when we met, and I believe it was at a survivors event that Miss Doris Strong was involved.
More strong.
Yes,
Yes.
yes. So
Yes.
yeah, so
Hmm.
I'm so glad we made that connection then. Yeah.
Yes.
So I'm gonna ask you to just tell the people a little bit about you in terms of who you are, not what you do, but who are you in your own words.
Who am I? I ask that question every day, depending on what I'm doing. I am. I wear many hats,
Mhm.
but basically, I'm an evolving human being trying to learn as much as I can to help others as well as myself, because I want to leave a legacy for my children so that they can learn to leave one for theirs. So we
Mhm.
can keep this generational wealth going. Generations is the key. We want to keep it going. We don't want it to end with us. So my
Right.
goal is to learn and to share.
All right, wonderful. Thank you so much for sharing that. And your in terms of your private practice, how long have you been in private practice?
This year, I will be 29 years. Actually, that bio's a little,
Made it
just a
right.
little outdated, but yes, I couldn't believe it. I'll be practicing attorney for 30 years next year. It
That
doesn't
is
feel it's been
amazing.
30 years.
That is amazing. That is
Yes.
amazing.
Mhm.
Wonderful. All right, so we got a few folks that have joined us. Naya's house. She said, "That's my mom." So she's giving some hand claps. Thank you for being here.
Yes. My
Yes, and
baby's always supporting me.
love it, love it, love it. And Donda, she said, "Hello, Attorney Thomas and all."
Hello, hello.
Thank you for being here. Thank you for being here, Donda. So, we are gonna get ready to dive into this topic. I guess I'm a little curious around your interest in this space in terms of wills and estate planning and that sort of thing. So, tell me how you kind of got started with that.
Well, when I get a client or it's who's probating the estate of a family member,
Hmm.
and it's a difficult time. It's very difficult.
Well,
But I've
no, not how you get started. What prompted you? Like, what motivates you to get started in this work?
right, yeah, that I was getting to
Oh,
that.
okay. Oh, okay. Go ahead. I'm
Yes,
sorry.
I've seen too many people who come in unprepared,
Mm,
and they have a lot of questions. There's usually some family drama,
mm,
um, things that were not discussed. Always somebody who feels like I should get this, and maybe somebody else should get that. Mama wanted me to have this, and the lack of planning just slaps you in the face. And no matter how many times I talk to people and explain how important it is to plan, because not planning leads to more grief. On top of losing someone, you've got all this paperwork, you've got to deal with the law, you've got to deal with family dynamics. A lot of that can be reduced, not eliminated, but reduced by planning. I know a lot of
mhm,
people who have family members who are exhibiting signs of dementia. They might have mental illness, but nothing's been done until it becomes a critical point. There's a crisis and everybody's on edge. And what do we do? How do we fix it? And there's a lot that can be done before they're. So that's why I'm beating this drum, because I know it's important. If you plan well ahead, when you're feeling good, everybody's thinking I'm going to live forever. I just feel so good, and
mhm.
that's the time to plan. Not
Right.
when, okay, somebody's 94 years old, uh, they're suddenly ill, or there's some catastrophe. Usually, is when
Right.
I see people. There's a catastrophe, and there's been no planning, and it comes out in my meeting. So I want to get ahead of it to let people know you don't have to be millionaires to have a will. You certainly
Mhm,
don't need to be a millionaire to plan for what will inevitably be the end of life. It's end of life planning. I mean, I've seen people plan for months for vacations,
mm,
and hours and hours, many, many conversations, but nobody's talking about what's going to happen to me when I can't take care of myself anymore, when I pass away. It's just left to those behind, and they are lost, they are hurt.
yeah.
It's just my way of trying to reduce it, reduce
Mhm,
that strain, that frustration. And I'm a little bewildered at how many people still aren't doing it.
Yeah. Okay. Well, thank you for sharing that. We have a few more folks that have joined us. Let's see. My mom down in Miami. Thank you for being here. Miss Potter, who is also down in Miami. I'm reporting again. Thank you for being here, Miss Potter. And my friend Marlene Mans, who is also in South Florida. Thank you for joining us. So, S.W. Ellis, who is here in Monticello, she says, what is the least amount one pays for probate?
Okay, so we're diving right into that.
She
It
is,
just
she
depends.
is. Yeah.
Right. It depends on the attorney. It depends on if it's a formal administration, which I would have to explain, or a summary. And every attorney's fees are different. So
Mhm.
it depends on how much work needs to be done. That's a question to be asked in a consultation.
Yes. All right. So let's take us through the process. Take us through the
Okay.
process.
Okay. Well, before we get into wills, I just want to share some sobering facts,
Okay.
such as over 70% of Black Americans do not have a will.
Mm.
That's a
Mm.
lot of people. And usually, parents of minor children are the least likely to have a will. We know we're going to be here forever to take care of our children, but what if we're not? What if something happens and you
Mhm.
got young children? Who do you want to raise them if there's no other parent available? Who do you trust to raise your child? So that can be done through a will, but a lot of people don't prepare for that. Um, Older people, I would say the silent generation is more likely to have a will than Gen Z. I don't know why it's becoming almost obsolete, but it's still necessary. And I know people have heard on the news when celebrities die, a lot of celebrities die without a will. That includes Aretha Franklin,
Mhm.
Bob Marley, Tupac didn't have a will, Prince, Billie Holiday, Sherman Hemsley from the Jeffersons, he didn't have a will. And so even when there is some form of planning, if it's not done right, it could take years to probate. So, for instance, it took 5 years to administer Aretha Franklin's will.
Mm.
It took 15 years to administer James Brown's will. So,
15 years.
15 years, that means 15 years of fighting, legal fees, frustration, 15 years. So,
That's a
that is
long.
not what you want to leave behind.
No, you don't.
So,
Wow.
So, a will is a written document and it expresses your desires for distributing your assets. So, if you want certain people to get certain things, you want to put it in writing so there's no confusion about what you intended.
Mhm.
The law only requires that you make provisions for a spouse or a minor child.
Okay.
But other than that, you can leave your property to anyone. You can leave it to a charity. You can leave it to a friend. You can leave it to anyone. But most people, of course, want to leave their assets to their family, their children, maybe
Mhm.
their siblings. So you put that in writing. You name a personal representative. Now that person is tasked with making sure your will is executed. That it can be a very daunting task, and some people may or may not be up for the task. That's why most people have a backup personal representative.
Okay.
Um, it requires that you hire an attorney to probate the will. There are fees attached, of course, the attorney's fees. Now, a formal administration happens when person has been deceased less than 2 years and their assets are $75,000 or less.
Okay.
A summary administration, the person has passed away, they've been gone for more than 2 years, and their assets are under $75,000. Now, typically, when there's property involved, land, a home, I typically like to do a formal administration anyway, because someone has to convey that property to the intended beneficiaries.
Okay.
That's a whole other topic with,
Yeah,
concerning
okay.
title and making sure you have clear title. But most title companies want a deed showing a person conveyed this property to another person.
Got
In
it.
summary administration, you get an order of summary administration. There are other things that need to happen in order to make sure you get that property. But back to the wills, there are a number of things you can do in that will. You can determine who gets what. You can set up guardianship for your minor children in
Okay.
your will. You can name that person. You most definitely have to trust this person.
Mm-hmm.
You can't say, I don't want my significant other or the child's father or the child's mother not to raise them. That's a natural right. But let's say they're not there. You're a single parent. There is no other parent. Who do
Mm-hmm.
you trust to raise your child if something were to happen to you unexpectedly? That you can put in your will, and though it protects your child. Now, there are common misconceptions about wills. The state will handle it. Well, the state will handle it. If you don't have a will, the state will decide who gets what.
Yeah.
The law determines. If you died intestate if you don't have a will. So the law comes in, decides, well, if you have a spouse and no children, the spouse gets everything.
Mm-hmm.
If you have no spouse but children, the children get it. So that's something that people should discuss, come in, see an attorney, and discuss the ramifications of not having a will. This is what could happen. They
So
think
let me
there's,
let me
go
ask
ahead.
you this. Are the things that you are mentioning pretty much the same regardless of what state you're in, or is this more specific to Florida?
This is Florida specific,
Okay.
but I can imagine most states, their laws are similar, but there
Okay.
are differences. So I'm Florida specific.
Okay.
So,
Gotcha.
right. So sometimes people think, well, my estate is too small. Well, if you have anything that's titled in your name, you have an estate, you have assets. A lot of people have cars. And if
Mm-hmm.
it's just titled in your name, that's an asset that can be probated. If you have a home,
Right.
that's an asset. So there's no cap on what you must have in order to have a will. But if
Mm-hmm.
it's something you worked hard for, you want it to go to a specific person, you should put it in writing. Now, later on, we'll talk about non-probate methods, things you can do to avoid probate. But we're talking
Mm-hmm.
about wills right now.
Okay.
So, right, and it says loved ones know what I want. So that's a mistake. When you say loved ones know what I want, uh,
Mm-mm.
that is not a will. A will has to be in writing. It has to be witnessed by two people, and a notary must be present to witness everyone, sign, watch the testator sign.
Okay.
And I've seen people come in with their own wills, either off the internet or they've drafted their own. Typically, they've signed in the wrong place, which makes it invalid.
Oh wow.
Um, right. And in Florida, again, has to be in writing. So you can't record it. You can't, they call it, because, they want to see this is your writing. You've signed. This is proof that you signed. This is what you wanted. There's no confusion. But thinking loved ones will handle it, that is a recipe for disaster.
Right.
Because
What's your thought on multiple copies of the will?
I would recommend two originals.
Okay.
You can leave one with the attorney. It's not mandatory, but you can leave one original with the attorney. You keep an original. You tell someone where it is, but make sure it's someone you trust.
Okay.
Make sure, and they know where it is, because you don't want a scavenger hunt after you've passed away and they can't find the will. Let's say
Right.
there is only one original. It cannot be found. You,
Mm-hmm.
you may essentially be intestate at that point, but at some point during the probate process, you find that original, it can be filed in the case. So it's important to have those conversations. I've had this conversation with my children, and it is very uncomfortable because you're talking about when I'm no longer here.
Mm-hmm.
And a lot of families don't do that. They don't want to have that conversation. It's awkward. There's some superstition around it. But these conversations need to be had. It might reduce some tension within the family because
Yeah.
if only one, let's say one child knows about what's going on, and maybe the mother has left a greater share of her estate to one child, then the other children feel left out. They feel that this child has coerced her.
Mm-hmm.
It just reduces tension. You just have to have that conversation.
Gotcha. So,
Hmm.
SW said, if I put everything in an estate, can it eliminate probate as opposed to a will?
Okay, a will is your estate. I think you're looking at non-probate options, and we'll get to that. Your estate is everything that you own when you pass away. Everything that's in your name, that is your estate.
Hmm.
And I always recommend a will as a backup, even if you do other things.
Okay.
So, well, we're just going to jump ahead to the non-probate.
Well, hold
Uh,
on. We got another
okay,
question related to
okay.
will. Donda wants to know, do the copies have to have a seal?
It's recommended that the seal be raised so
Okay.
that you know that it's an original, but it's not mandatory. I have filed many, many wills that don't have a raised seal, but you do know it's the original,
Okay.
usually in colored ink,
Okay.
so that copies, you can file copies in the probate, but the original must be filed along with the death certificate. Those two
Gotcha.
things are absolutely mandatory.
Okay. All right. Naya, is there ever a case where you can give someone else permission to amend your will? Mm,
Well, that is a good question. It depends on if you have a durable power of attorney, which is another estate planning tool.
okay.
Um, but I recommend that if you want to change your will, you just amend it. A will is a fluid document. You can change it as often as you like, for as long as you like, until you take your last breath. You can
Gotcha.
leave everything to one child in one will, and then in the next one, you left it to somebody else. The
Mm,
each successive will revokes the prior will, so you can change it as often as you like. So
okay.
it's not a one and done, because your will should change with your life circumstances. You might make a will when you're single, and maybe you
Mm,
leave everything to your siblings. Then you get
mm-hmm.
married, you got a husband, then you might get divorced, then you have children, then
Mm,
grandchildren. It should change with your life.
okay. That makes sense.
Yes.
All right. And each time you would have to have it
Uh,
notarized, witnessed
yes.
and
Each
notarized.
time,
Right.
each time
Okay.
you can either, um, if it's major changes, I would do a new will. But if it's minor changes, a codicil, which sort of like an amendment, that's an amendment, but it would have to be uh, witnessed and notarized just like a will.
Okay.
Hmm.
Okay. Okay. Very good.
Hmm.
One of your children is on here saying, "Go, mommy."
Hi, Dahlia.
Yeah, thank you for being here.
Yes,
And we got
Dahlia, yes. Hmm.
yes, and we got
Yes,
Miss Lisa on with us as well. Good information. Thank you, Lisa.
yes,
All
yes.
right.
So this is information anyone can get. Spend a few dollars to go and talk to an attorney before you do anything.
Yeah.
Um, People are afraid of the cost, but just a consultation can tell you everything you want to know. You might not do anything for maybe a few years, but at least
Mhm.
you know what you need to do. It's
Yeah.
better to know what you need to do and not do anything right then than to have it in your face at that moment and nothing's been done.
Mhm.
So all of
Okay.
this estate planning is, having your house in order for that day when you can't do it yourself, or you
Right.
passed on.
Right. Uh,
Yes,
Don, the durable power of attorney expires when the individual expires.
absolutely correct. There are
Okay.
two types of powers of attorney. There's your power of attorney, and then there's your durable power of attorney. The
Okay.
power of attorney expires when the person is incapacitated. They're unconscious. You can't act if, they can't make a decision. They're not conscious. A
Mm-hmm.
durable power of attorney is still active if the person's unconscious, but
Okay.
they are both immediately revoked once the person passes away, that
Gotcha.
very moment. And I've heard stories of people still using those powers of attorney after a person has died.
Mm.
That is improper. It could be illegal. There are penalties attached to durable powers of attorney if they're used incorrectly.
Okay.
It's why you have to trust who you give that authority to. It's a great deal of authority. And I
Right.
know personally people who were taking these and they went out and cleaned out people's bank accounts. They had, purchased vehicles for themselves or changed the title. So I urge you to please consider who you're giving this authority to with any of these documents. It's all
Mm-hmm.
about trust. It might
Yeah.
not be your children. It might be a best friend, maybe someone who can be objective in terms of executing these documents. They're
Mm-hmm.
still emotionally attached to you, but they can do what you've asked.
Gotcha. Okay.
Okay.
Would the appropriate person, I guess after, well, you said a personal representative. Would that be
Yes.
the appropriate person after you have transitioned, after
Yes.
you passed away? Okay.
Yes. That's the person either named in the will or
Okay.
appointed by the court in an intestate probate.
Okay. Got it.
Mhm.
Lisa had a question. She said, "Do you have to submit this to court?"
The will? Are we talking
Uh,
about the will?
maybe. Lisa, give us some clarity on what this is. All right. Just let us know in the comments.
Right. If we're
And Miss,
talking about wills, the courts used to allow people to file their wills beforehand in the court registry. I
mhm,
understand now they just don't have the capacity to do that anymore. So
gotcha.
the original will must be filed with the probate, which is important that it's up to date, it's what you wanted, and it's somewhere where it can be found. I would suggest talking to the personal representative, the person you designated, because sometimes people don't know you've chosen them, which is
Mhm,
why you should have conversations. Ask them,
right.
do you want to do this? Would you do this for me? So that
Mm,
they know. And it's not a bad idea to talk to the attorney about what does this entail. Because some
mhm,
people find out after someone's transition, okay, well, what do I do now?
mm.
Hmm.
Gotcha. Okay. We got a lot of comments and questions, so uh, let me scroll up. Let's see. Miss Robbie Moran is on. Excellent and
Thank
valuable
you.
information. Thank you for being here, Miss Robbie. Uh, Dr. Rhonda Blackwell Flanagan, Attorney Thomas, highly recommended. She was the perfect combination of intelligence and expertise. Thank you for that
Thank you,
endorsement.
ma'am. Thank you.
Yes. All right. So SW wants to know, wouldn't it be wise to get the person's permission before you submit their name? So I think you already answered that.
Right. It's not permission, but
Mm-hmm.
they can refuse to serve. So
Okay.
that's why there's a backup. If the language is if they are unwilling or unable. So it's not
Okay.
mandatory. If they put you in there, they probably trust you. But
Mm-hmm.
again, you don't want to be surprised when someone passes away and you find out, oh, I'm the one who's supposed to handle all of this.
Right.
And there's all this family over here and people are angry and upset. That's not what
Mm-hmm.
you want to find out. So
Ew, he
again,
definitely. don't want to find out like that.
All about communication.
It is. It is. It is. All right, Marlene. Let me see. Marlene said, "Does the person who has the power of attorney need to be on the bank account to withdraw money?"
Not necessarily, because these powers of attorney can be submitted to third parties, such as banks. And
Mm-hmm.
a bank will vet that document before they allow you to touch any money. But
Mm.
once you're allowed to do it, you should do it responsibly. Now, I think what this seems to be referencing, maybe a beneficiary
Mm-hmm.
on a bank account. It's a non-probate method. You can
Okay.
add beneficiaries to your bank accounts,
Mm-hmm.
and you show the bank the death certificate, and that money's turned over to you. It does not go through probate. But if you add someone to your bank account, they are a joint owner. So it doesn't matter where the money comes from. It could be, say you hit the lottery and $500,000 is in your bank account, and the other person has $10 in there.
Mm.
Well, you both own $500,010, and the person you've added has access to all of that. So you're a co-owner. So you also have to be careful about adding joint owners.
Right. So who you
Okay.
make beneficiaries, right?
Well, you can name a beneficiary. You still control your own bank account, all of that money. But
Mm.
when you're naming someone in your power of attorney, they have access to those funds, which is
Gotcha.
why it's important that you trust who you give that authority to.
Gotcha. Okay.
Mhm.
So just let me pause quickly. We are a little over halfway through our talk. The
All
questions
right.
are rolling in. We're talking wills and estate planning. I'm on with attorney Felicia Thomas, who is here in the Tallahassee area. And Felicia actually was one of our sponsors for the Generational Wealth Matters community conversation that myself and Sheila Morris put on back on April 7th at the Signature Lounge. And we covered probate,
Yes,
heirs, property, estate plan, economic empowerment. It was a lively discussion. We are
yes, it
planning
was.
another one of those events in July, so definitely stay tuned. And Felicia will be on our panel for that discussion. So we are looking forward to that. All right, so we got our clerk of courts, Gwen Marshall, on the live tonight. Thank you for being in here. And she said wills can be recorded with the clerk of courts. So,
Well,
and
I'm glad to know that. Yes.
yes, yes.
Great.
All right. Keisha Washington, greetings, God's people. Thank you for being here. Adalia said, how many witnesses do you need?
You need two witnesses. And
Okay.
I recommend that they not be related. And I
Mm-hmm.
recommend that the notary not be related to any of the parties.
Okay.
Anyone who's a beneficiary of the will should not be a witness.
Okay. Good to know.
Yes.
All right. So Steph also said, didn't know that. Our honorable Gwen Marshall, thank you for sharing that. And Lisa said that you did answer her question. All right.
Okay.
Steph said payable upon death for bank accounts.
Yes.
Okay.
That's what I just mentioned about adding beneficiaries to your bank account. So it
Mhm.
automatically passes to them upon your death. But, proper documentation, the bank will vet it. So
Right.
if you are already listed, that's one way to avoid probate.
Okay. Very good. Thank you for
Mhm.
that question, Steph. Janetta, she said, if an unmarried person is living in the home of the deceased, does the representative who has the judiciary estate need to give requested items to him or her?
Okay, unmarried. Well, does this person have a will? Because the person can leave assets to an unmarried partner.
Hmm.
If you're unmarried is the key there. If you marriage brings a lot of protection, so, but if you're unmarried, it just depends really. Um, I'm assuming representative, you mean the personal, the PR.
Yeah, maybe the personal representative. Yeah.
It just depends. That could be a contest there because it depends on who purchased what, who bought what
Mm-hmm.
into the house. So that
Okay.
would be a question at a consultation.
Okay. All right. Thank you for that question, Janetta. Donda said, what happens in the event the designee is unable to carry out the authority given months or years later?
Under the power of attorney, I'm assuming
Okay.
under the power of attorney, sometimes there is a contingent
Mm-hmm.
attorney, in fact, in those powers of attorney. If they can no longer, there's a provision for that. So
Mm-hmm.
if you're unable to serve as the attorney, in fact, under the power of attorney, there should be some language in it.
She said yes.
Yes, to prepare for that contingency.
Okay. All right. Janetta came back and said assets are willed to the personal representative. So going back to
Well, no, they're not willed to the personal representative. The assets are managed. The personal representative is responsible for making sure those assets are distributed to the persons who are supposed to receive them, either under
okay,
a will or intestate. So
gotcha.
they are managing it. They are responsible for it until it gets into the hands of the intended beneficiary.
Okay, very good. All right. We got Nick Rains in the house. Thank you for being here. And Miss Brittany has joined us too, who is here in Tallahassee. Thank you for joining us. So, woo, this is this is a lively discussion, and y'all have
Yes, yes,
really great questions, which
yes.
I absolutely love. So I just want to make sure I didn't miss anybody's question or comment. Okay, I think I got them all. So some common mistakes that you see. I mean, you've talked about some of them, but what are some others that maybe you see that we may have overlooked?
Well, not including everything that you own. You might think that this isn't important, but
Mhm,
and again, not updating your will, because if you make a will and you were single when you drafted it,
mhm,
and now you since had children, a husband, the law will conform it, but I
mhm,
think you want control of that.
mhm,
Um, yes, so a will is important. I want to share this story. I heard recently about a young man who was
mhm,
dating this woman. He really liked her, but then his father started dating her, and they
mm,
got married. So the young man, of course, was crushed, but he moved on. Years later, he got married, had children. But sadly, his wife and children died before him, and he did not have a will. So when he passed away, his only living relative had been his father.
mm,
And when the father died, his assets would go to the woman who he initially dated and then married his father. So
mm,
it sounds like a soap opera, but these things happen. So I suggest to people who are in marriages, maybe they're separated. Florida doesn't recognize legal separation. So if you're still married to somebody you haven't seen in maybe 10, 15 years, and you assume that, everything will go to my children, well, it will go to that spouse, wherever he or she is. So, um, so either you
mm.
go ahead and get the divorce, or you just expect this person to just come back into maybe your children's lives and they take everything. So you have to plan. You have to plan properly.
Whew,
Uh,
that's
it
rough.
happens. It happens.
Ooh,
So
Lord
um,
mercy.
it does happen. So I just encourage people, just go in, have a conversation.
Mm,
It might be frightening, but it's a good step to take. I mean, people plan their Thanksgiving dinners more vigorously than, their end of life. So just come
You
in.
you are telling the truth, ma'am. You are telling the truth. We do. We
Yeah.
absolutely
So,
do.
other non-probate methods can include transfer on death deeds. We call them
Mhm,
ladybird deeds in
mhm,
Florida.
mhm,
You own your property. You leave a life estate for yourself. You still own the property as if you own it outright, as if there were no ladybird deed. You
mhm.
can sell it, you can rent it, you can do all of those things, but if you still have possession of it when you pass away, it automatically passes to the person you left it to. They're called the remainder.
Okay.
So that's one way to avoid probate. You can handle your title to your vehicle in such a way that it passes without going through probate. So
Okay.
if you have any assets that have a title and that you can add a beneficiary to it, you can
Mhm.
avoid probate. But I
Okay.
always recommend having a will as a backup in case something falls through and you still have this asset hanging out there. There's some question about who should get it or what's going on with the title. You
Mhm.
still have your will to catch it. So
Gotcha.
I also recommend, make a living will. So in
Okay.
terms of being ill, um, chronic illness, you're in a vegetative state,
Mhm.
uh, and if you want to be kept alive by artificial means or not. So a
Mhm.
living will lets everybody know, your family, your doctors, that in the event that any of these things happen, I want you to let me go. Just let me go. Then there's no question
Mm.
about what should be done, because without it, you have maybe one child saying, I want to keep mama alive. The other one says, no, mama wouldn't want to live like that.
Mhm.
Here the doctors are like, they're worried about, okay, what should I do? And eventually a decision will have to be made. But it's
Mhm.
best that you make it before we get to that point. You put it in
Right.
writing and you let everyone know. Again, give it to the people in your life that need to know. Give it to
Mm.
your doctor. So I
Okay.
call that estate planning. So you're taking care of your health, you're taking care of your wealth with
Mhm.
these documents. A healthcare surrogate is someone who can make decisions for you while you're alive if you're unable to make them yourself.
Right.
Again, um, with dementia or any illness that robs you of your ability to make decisions, you got
Mhm.
someone you trust that knows what you want and can make those decisions for you.
Yeah. No, that's important.
Yeah.
Real quick, my sister has just joined us. Shay, thank you for being here. She's down in Miami. Tara, thank you for being here. She said, yes, having a will is so important, and filing it with the court or telling people where it is helpful. Absolutely. All right. And
Yes.
Esther has another question. She said, can you put names on property as tenants in common to prevent spouses or children from becoming attached to the property?
Okay. Well, tenants in common, it depends. Again, the law won't allow you to disinherit a spouse or a minor child, but you can have property with, say, a sibling. Tenants in common means you both own it 50%.
Mm-hmm.
And that sibling might have children and she or he may leave it to their children. So when you're talking about preventing things, that's a conversation you might want to have. You see if you want to craft your estate documents in such a way so a certain person you don't want to get it. So
Mm-hmm.
yeah, those questions you need to sit down with someone and say, okay, what is your goal?
Right.
What is it you're trying to achieve? And let's see what can be done and what can't be done.
Okay. Okay. Thank you for responding to that. My cousin Nora is on. Great information. Thank you for being here. She's in Virginia. Miss Jeanette in Miami Gardens. Thank you for joining us. She said the book Swish Five Wishes. Five Wishes can be a
Yes,
tool. Yes.
yes,
Yeah. Okay.
absolutely.
All right. All right. Naya said, can wills include funeral arrangements as well or just manage assets and finances?
That's a good question. You can definitely include funeral arrangements
Okay.
in the will.
Okay. All right.
Yes, you
Very
can.
good. Okay. Rhonda, what happens in the event the money in the bank? What happens in the event money is in the bank? Maybe when a person dies, but it was missed on the will and no one listed as beneficiaries.
Then let's see what happens. Well, then it becomes part of the estate. As long as
Mm.
someone knows where it is, because banks will not discuss it with you. They won't
Mm-hmm.
tell you anything until a personal representative has been appointed. So it
Okay.
might not be in the will, but it's still an asset.
Okay. All
It's
right.
still an asset.
All right. Very good. Good question. Thank you, Donda.
Yeah.
All right. And Mama Yada has joined us. Great information. Thank you, Mama Yada. All right. Wow. So did we kind of go, did we talk probate at all or no? Do we still need to cover
Well,
that?
well, we did in a way. So like probate,
Roundabout.
the
Roundabout.
legal process, yes, you so the personal representative, if there's a will, and even if there's not, a personal representative needs to be appointed. That person would hire an attorney. The attorney would draft the documents, file them with the court, which must include an original will and the death certificate.
Mm-hmm.
Okay, the decedent's creditors must be noticed. If they're known creditors, they get um, 30 days to make a claim against the estate. Unknown creditors get 90 days. They get it by publication in a newspaper.
Okay.
The personal there are other uh, duties involved, like such as doing an inventory, making sure the estate assets are protected, certain bills of the estate are taken care of until notice to creditors has been sent out to everyone and they've had the opportunity to file a claim. The other important thing is if you're 55 and older when you pass away, the personal representative must find out if that person has a Medicaid lien.
Mm.
Yes, Medicaid, it recovers any benefits it paid on your behalf. If you're 55 and older, you must find out, because you do not want to find out once the probate is closed that you have a $70,000 Medicaid lien. So that's due diligence of the attorney and the personal rep. So even if mommy never had Medicaid or she had her own insurance, you still have to find out, because in terms of creditors, they're near the top, if not at the very top. Um,
So how do you
so
find it out? You just submit a request to Medicaid?
yes, there's they have a third party recovery department, and
Gotcha.
that's something that should be done early on, because sometimes it takes them a while to get back to you, and you must stay in touch with them often. So and it's great to get a letter saying that this person was not a Medicaid recipient. So
Mm.
so creditors have to be satisfied. An attorney can negotiate some debts, or if there are no debts, then we're at the point where assets can be distributed. But this is, several months of work,
Mm-hmm.
and the more people cooperate, the quicker it can be done. It lessens the fees, but if there's a will contest,
Mm-hmm.
people might get their own attorneys. Um, they have the right,
Yeah.
but it can prolong the process and make it very expensive,
Mm-hmm.
especially if there's no will. So um, I highly recommend again that people talk. They talk to
Yeah.
each other.
Yeah.
Everybody, have a end of life planning
Mm.
session. It might
Yeah,
not sound great, but it's necessary.
it is.
Understand you had session recently about taking care of someone with dementia, Alzheimer's.
Mm-hmm.
Sometimes before those signs become apparent,
Yeah.
those these plans need to be put in place. You know, when you're good and healthy, that is the best time to do it. You
Absolutely.
know, when you think, okay, nothing's ever going to happen to me. I'm going to live to see 90.
Right.
We can't make those assumptions, but
Mm,
you know, when things are going well, you know, sit down and make these plans.
yeah. No.
And
Absolutely sound advice.
right.
Absolutely sound advice. So Tara wants to know, do you offer consultations?
Yes, I do.
All
Yes, I
right.
do.
Very good. All right. Keisha
Yeah.
said my family had that prevention conversation on my mom's side and has me executive because all my siblings are married. Only if she had talked about sex prevention. Keisha is my show comedian, so just give me a heads up. Anyway, I love you, Keisha.
Yes.
All right, Naya, how else would you recommend putting families at ease with superstition, such as wills, putting an expiration date on your life, or avoiding court at all costs? That's a great question.
It is a great question. Well, that sometimes you can't get around people's superstitions, but you can share with them, you know, this person made a will when they were, let's say, 30, but they didn't
Mm,
pass away until they were 90. And then again, you have people who die suddenly without a will.
mhm,
They never made a will and they still passed away. So it's not something you can get away from.
right.
And in terms of settling your estate with or without a will, there's going to be some cost somewhere.
Mhm,
Either preparing a ladybird deed, there's a cost, or having a will drafted, there's a
mm,
cost. Going
mhm.
to court, there's a cost. So it's unavoidable.
Yeah, there's going to be some costs.
Right.
All right. Steph wants to know, is a trust better to have than a will?
Well, it depends. Trusts are a legal entity separate and apart from you as a person. There
Mhm,
are tax implications. It just depends on what you want to put in the will and what it is you want to achieve. Now, a will is, you know, manage your assets. Once they're been distributed, you're
mhm,
done. It's all done. A trust, you can manage those same assets for a much longer period of time, long after you've passed away. So it just depends on what your goal is.
gotcha. All
Mhm.
right. SW, what is the clearest way one can ensure no probate will happen without fees?
There is no way to ensure. There is
That's what
no
we're trying to avoid, that probate, boy.
right. You can avoid probate, but there can be fees attached. I mean, if you want to do it yourself, you know, if you have a home, you want to do a ladybird deed, there's a cost for that. But in
Mm,
terms of bank accounts, you can add beneficiaries to those accounts.
mhm.
That
Okay.
avoids probate. So unless you don't own a home or any other asset titled in your name, then there may be a way. I can't guarantee that, but usually dealing with your end of life planning, there's going to be some cost somewhere.
Mhm,
And doing it yourself without having some kind of legal overview, you may cost yourself more,
mm,
or whoever's handling your assets, it may cost them more because, you know, all of this was done incorrectly.
mhm.
So if
Indeed.
you want to do it yourself, at least come in and have an attorney, talk to an attorney about what it is you want to do and how you want to do it.
Good advice. All right. Lisa
Mhm,
said, I'm now drafting my ladybird deed. All right. Very
mhm.
good. Let me see. Donda, how do you handle when a will has been drafted and you discover there are siblings outside of the individual who the will represents?
Well, it depends on what the language is. If these are minors, if there's a spouse, there are a
Mm,
lot of little nuances that can change what happens in that will.
mhm. Consultation.
Yes, consultation.
Yes,
And it
yes.
does happen. It does
All
happen. So an
Yeah.
attorney would need to look at that will and see what was this person's intent. And then how does the law look at these outside
Outside
children?
children.
Mm-hmm.
Yes.
Yes.
Mhm. Yeah. Got it. All right. Hey, D. Bradley. All right. Keisha wants to know, is any of these costs tax write-offs? No, Keisha.
Not for your end of life planning. It's an investment in you.
Lord have mercy. I told you she's my resident comedian. J. Air, does county of residence matter, or can someone in Central Florida consult with a North Florida attorney?
Yes, you can. Yes, you can. But I always recommend that you find an attorney who's practiced in that particular county. For instance, if I'm up here in Tallahassee, you're in Miami, and I have to deal with Miami courts, which I don't do often. Miami attorney knows, the judges, how they like things, but nothing prevents you from consulting with an attorney outside of your county.
Okay. Ms. Jeanette, can the Ladybird deed be revoked?
As long as in terms of destroying it, yes. If the person's still alive, they can, they still own that property. They can sell it, they can rent it, and if there's nothing there when they pass away, there's nothing to leave to that beneficiary.
Okay.
It
All
just
right.
depends on how it's drafted.
Okay. And Naya, can a will be compromised if the deceased had a criminal record? Comprise, not compromise,
I
comprise.
think I think she
Can a
meant
will be,
compromise.
you think she meant
No,
compromise? Okay.
yes. No, if as long as the assets they have are, they're legitimate assets.
Okay. Okay.
No, you can have a criminal record and go on to, become a millionaire,
All
make a
right.
will, or not, thousandaire, and you can still have a will in your criminal record. But we've seen lots of movies where people have murdered folks to get their money early. We understood, sweetie. They to get their inheritance early. Well, you can't inherit from someone you've murdered. I don't know if you know.
Okay.
If it's proven,
That's a whole nother case.
the whole
All right. My classmate Steven Simpkins just joined us. He's in Gadsden County. Thank you for being here. All right. And Miss S.W said, thank you. It was interesting. She said, a phone about to cut off. All right. Very good. So we are, this has been a robust conversation, but we are at the
Yes.
end of the conversation. It looks like we're going to have a whole bunch of folks coming to our next workshop. Attorney
Yes.
Thomas, with all these
Yes,
questions
please
that we
come.
got. Yes. So I'm going to give you an opportunity to give some closing remarks and tell folks how they can connect with you.
Yes, it's become my mantra. Make plans, plan early, and update it often. It's better to do it when you don't need it right then than to need it and you don't have it. Have that conversation, as awkward as it might be. Just have the conversation. It's a show of love. It's a show of taking responsibility for yourself, for your family, and it's a loving thing to do. And I can be reached at 850-366-3910. I can also be emailed at info@fswthomaslaw.com. And I look forward to having you reach out to me.
All right.
Any attorney, probate attorney. Just have those conversations with your family and an attorney.
Very good. Very good. Well, thank you so much for taking time to talk with us tonight. I hope you all found this to be helpful. If you did, let us know in the comments. Give us a heart, a thumbs up, a clap, something, or just a thank you to let us know. We try to bring interesting and intriguing topics. I think this one is really, really important, and we definitely need to take steps to get our house in order. The wills, the ladybird deeds, the beneficiaries, the power of attorneys,
Yeah.
all of that stuff, we need to be doing it.
Mhm.
Like, making plans. This might not be a good time this month or whatever, but plan for next month or next quarter. But we need to get that done. Like, that's one thing that I'm really definitely, I will be first to say I do not have my house in order as relates to all of that. I have one son, I'm unmarried, so part of my thinking is it'll just all go to him, but
Yes.
I need to put it in writing.
Yes.
So
Put it
I
in writing.
planning on doing that. And look, you talked about people turning 55. I'm turning 55 in July. So I'm like, wait a minute, she talking about me. Ooh, child. Yes, but
Mhm.
yeah, we got to get our houses in order, y'all. We got to do it. We
Yes.
got to do it. We got to do it. All right. So we have several comments. Naya, thank you, Miss Nicole and Mommy, for a great conversation. You're welcome. You're welcome. Nick, great
You're
conversation.
welcome.
Information. Thank you. Thank you. The total view. Thank you for the value information. You're welcome. J
Yes,
Air.
you're
Thank you.
welcome.
You're welcome, Shayla. Yes, Donna. This has been great. Thank you, Steph. Thank you for being here, Steph. Definitely helpful. Thank you, Iris. Thank you, Lisa. Thank you. All right. Mom said if one of the parties on the deed dies, do you have to go through probate to remove their name?
Okay, one of the parties on it. It depends on the type of deed. Are we talking about a ladybird deed? This might be something we can talk about after the show.
So,
Yes.
yes, we can.
Mhm.
Ma, we'll get it squared away, Mom.
Yes.
All right. Keisha, the side chicks, baby daddies, in-laws. Yes, all of them. All that need to be taken care of.
Yes.
Put it in.
Yes.
Don't play around.
Put
Put
it
it
in
in right.
writing.
Yes. All right. Steph Thomas. Okay. Thank you for being
Yes.
here. I haven't seen you in a minute. Thank you for being here. Tara, great show. Thanks for the information. I'll be calling. Wonderful.
Yes.
All right. Marlene, awesome advice. Thank you. Thank you. Thank you. Y'all, let's keep this conversation going.
Yes.
There's so many of us that again don't have our house in order. So please pass this link along to a friend, a family member, a loved one that you think can benefit from it. And let's have these conversations and let's make sure we have our documents together. All right. Can't stress that enough. Thank you again, Attorney Thomas. Again, y'all be on the lookout for that July date for this Tallahassee generational wealth event that will focus on this very topic. It'll be free and open to the public, so we invite you all to come out, but we'll be posting about it very, very shortly. All right. Well, y'all have oh, wait a minute. One last question. Hold on. What happens if a sibling signs over property to themselves before the parent's death? Ooh,
Yes. Next time.
yes. Yeah. Listen,
Mhm.
come in
Yes.
July. If you're here in
Yes.
Tallahassee, you'll have to come in July. We'll answer it then. All right, y'all. Have a great evening, and we'll see y'all. So have a happy Memorial Day weekend, long weekend. So
Yes.
we'll see y'all next week.
All right.
Bye.
Bye-bye.